Now, he's been fined that. This is some time ago. What's the damage to the car, sir?
The vehicle itself was worth £900. Obviously, when it was taken from the motorway, it was taken to the compound where it was accruing point and daily fees. Obviously, there was a fee to get it out of the compound, which I have with me today.
How much?
£290 in total. I've got that here with me. And
Seen it.
And then we had to have it. It was unfit to drive, so we had to pay for it to be taken away and sent to a scrapyard, which was obviously a £90 charge.
£90?
Yes.
So the total was £1,280?
Yes.
Now, this is very important. At some point, he agreed to pay some of it back.
Yes.
What was the agreement you came to?
We agreed that in January this year, he would start paying at the end of each month £100 a month, which wouldn't, you know, trouble his personal circumstances, and it would be payment of intent, which was, you know, and I agreed to it because I was very grateful given his circumstances.
So you gave him a chance. You wanted to be a friend. I'm not worried by that loan agreement. Just to be clear, you presented this case as if it's a loan. In other words, what you said is, Judge Rinder, I had an agreement with him to pay me money each month.
It was a verbal contract between
Not worried about that.
Yeah.
That's not the legal basis of your case. It's not a straightforward loan. The question is whether he was negligent, whether he owes you the money to put you in a position you would have been if your car hadn't been smashed by him. Understood?
Understood.
Don't worry about all this. It's purely about you giving him a chance.
That's right.
£100 each month. Not a big ask for somebody who's working. Could you have afforded that?
Yes.
How much of it has he paid?
He paid £50 in January. Obviously, I can provide evidence of that as well. And £50 in February. Obviously, since then, we've not received anything.
£100 in total?
Correct.
Where's the rest? What's funny?
I'm not laughing.
Where's the rest? Me either. Where's the rest?
I got made redundant from work, so I couldn't...
Was that after the second £50 was received? Was that afterwards? Where's the rest of it? Has he come to see you, speak to you?
We've bumped into each other. It's been quite traumatic getting older, Damien. Obviously, I sympathise with his situation, but at the same time, you know, we've known each other a very long time. A group of lads, as a code of conduct, we adhere to the lad Bible. You borrow something off somebody, you pay him back.
What's the lad Bible? On the third day he drank?
No, you should know. You should borrow something
and
off somebody.
And hence lo came the birds. And on the fifth day he read page 3.
I mean, it's not my place to say, but he was earning money from football as well, so I pleaded, is there any chance of...
What do you mean he was earning money from football?
Well, he's a very good footballer. You know, for the teams that he was playing for at the time, it was paying him to, you know, represent their team.
That's true. You were getting bits of income, and I understand that you had other expenses and considerable personal overheads. Correct?
Yes.
I understand that. But, sir, tell me exactly what was going on financially for you at the time.
Well, I just had a breakup with my ex-partner and we have kids together. I have another child with another woman, and the maintenance was taking money out of my wages.
Expensive things, children.
Yes.
Damien, you lent Damien your car. You're entitled to 2 things. Number 1, you're entitled to be confident that he was going to look after it. And secondly, you ought to have checked, but it was a matter for him in law to insure it. Simple as that. Although there are certain circumstances in law where it is your obligation to ensure that the person taking your car is insured. I do not consider this to be one of them, but nevertheless, you've got to be very careful. He took the car, he misrepresented what had happened to it. What had actually happened was that he'd crashed it and it was his fault. The consequence in law is very simple. He owes you the money for it. And what's more, had he been frank about it in the first place, and had he got insurance, he would never be here. But nevertheless, the reality is, regardless of what agreement you subsequently came to, it's all irrelevant. You're entitled to the full sum of putting yourself into the position you would have been in but for his negligence with the car. And in the circumstances, your application is for £1,180, which is taking into consideration the £100 he's repaid. Your claim is for £1,180. You're entitled to the lot of it. And this court awards you £1,180 and says this, sir: I know you needed a vehicle, and I don't think you're a bad person. And I have an intuitive sense of why you told porkies. But had you been up front from the beginning, you wouldn't have affected this friendship, and above all else, you wouldn't have found yourself here, I suspect. Understood?
Yes.
The order of this court is £1,180. I wish thee thy best luck.
David won his case and was awarded the full amount of his claim.
If you enjoyed that video, then I strongly suggest clicking here for more highlights. For those of you who haven't subscribed yet, and why not, so that you never miss out, subscribe. Clicking down there, that's an order.